Welcome and good morning. Thank you for attending this Zoom webinar from around the globe. Before getting started, I just want to remind everyone that the session is being recorded and will be put up on the website. My name is Kyoko Yoshinaga, and I'm the non-resident senior fellow at the Georgetown Institute for Technology, Law, and Policy. I'm very pleased to welcome you to this series on AI governance, co-hosted by the Georgetown Institute for Technology, Law, and Policy and the Yale Information Society Project, Yale ISP. It is also co-sponsored by the Georgetown Global Tech Networking Group, which is made up of international academics and experts who specialize in technology law and policy research, led by Professor Anupam Chander. Today's panel is on the geopolitics of European AI. We'll be joined by three experts in this area, which the moderator will going to introduce you in a minute. And our moderator today is Nikolas Guggenberger, who is the Executive Director of the Yale ISP. With that, Nick, the virtual floor is yours.
Thank you so much for this kind introduction, and also hello from me. It's my great pleasure to introduce this wonderful panel. We couldn't have better people to discuss the geopolitics of AI today. I'd like to welcome Vigjilenca Abazi, who is an assistant professor of European law at Maastricht University, and Przemyslaw Palka, an assistant professor of law at Jagiellonian University in Poland, and he currently leads a project titled Private Law of Data. And finally, last but certainly not least, Kirsten Rulf, who calls herself nerd-in-chief at the Federal Chancellery of Germany, but is formally the head of unit for digital and technology policy at the German Chancellery. Welcome, and thank you so much for joining. I would like to kick it off with a sort of very general set of questions to give everybody the chance to set the stage for this conversation. And let's start with Vigjilenca Abazi. Vigjilenca, where are we headed when it comes to European AI and to European AI policy?
Thank you so much, Nick, and thank you once again to the organizers for inviting us in this very important topic in a very timely manner. Just before I begin with the substance of your very interesting question, I would like to say a word of solidarity to our friends and colleagues in Ukraine. It's a very sad and troubling period. And of course, we cannot talk of geopolitics of Europe, regardless of AI or anything else, without taking that into account. But so moving more to the point of our discussions today, I think what's very important to see actually before sometimes looking forward helps us to know where we stand going forward by looking back. And I think looking back and sort of the development of this piece of legislation, which of course to emphasize for those in the audience who maybe are less familiar with EU legislative processes, which can be quite bureaucratic and long in Brussels, this is obviously not yet a law, just to be clear, and this is sort of a thinking period from the proposal that was put forward last year by the Commission. In a way, what it shows is the ambition, once again, that Europe has in terms of its legislative capacity and trying to make sure that similar to the GDPR, when it came down to issues of consent and empowerment of individuals, similarly to try to make sure that with AI, that we're making front and center some of the issues that are, from a value perspective, considered so important in Europe. Now, of course, this is maybe also easier for European legislator to do simply because, as we're realistically know, a lot of the development of AI and a lot of the use of AI is actually not as prominent in Europe as elsewhere, particularly in the US, for example. So in that sense, there's more of a margin of inserting certain rules. I think some of the main challenges that I see going forward, and of course, a lot has to be decided and seen because as lawyers, we know that usually the devil is in the details. So we're yet to see the exact wording and all the final provisions that will be adopted. But predominantly what I already anticipate to be two main issues is issues of compliance enforcement, that I would bucket this into one area, and transparency. To start with the latter very briefly, because I'm sure we'll discuss more as this panel unfolds today. Basically, issues of transparency remain still quite undefined in the current ambitious proposal on the AI legislation, especially when it comes to the kind of transparency that we would like to see versus more the individuals and the public. So a lot of the provisions actually, whether they deal on the sort of what can be called the pre-market conformity assessment or sort of the post-market monitoring duties, neither of these pre or post-market sort of structure, if we can think about it in the kind of obligations that the law imposes, are clear enough or require sufficient of transparency that we would like to see from an individual perspective in particular. So there, one could argue there is a slight of a mismatch between some of the ambitions that are stated in the preamble and some of the wording around also human rights and all those values with what we're specifically seeing. And to give some, just to throw some examples here to make this a bit more concrete, this especially comes down to issues around surveillance and face recognition and sort of the kind of approaches that we're going to be seeing there. And I hope I'm still within my opening time, but just to quickly show, to give a point within the enforcement aspect, that too remains quite a challenge. And I think the practice of GDPR shows that although the Commission is not timid to impose hefty fines that we've seen lately with, for example, in the WhatsApp case, still it remains problematic in how that's going to work on the ground and whether that's going to have sufficient detail, especially if we're going to have more of a horizontal approach. So I'll leave it at that for the moment, but there's, I'm sure, a lot to discuss further. But a few of the challenges, indeed, just to sort of summarize that I see remain in these two predominant fields in terms of the, not just whether we have a good law, but whether even if it's not a sufficiently ambitious law or broad enough, how will it actually work in practice? Are we just creating more of a dust screen, or will it actually make sufficient changes that we would like to see? Thanks.
Thank you so much. There is certainly more to be discussed, and we will try to cover some aspects of that. Just to make sure that everybody is on the same page, you mentioned pre and post market assessments. Could you just for the audience maybe clarify what that is specifically?
Yeah, so basically the regulation divides certain, so basically we have a different sense of risks, of course, and that was part of the issue in terms of what can be defined as high risk for the purposes of regulation. So the regulation takes sort of a three-tiered approach in this sense in terms of defining what high risk can be. And then when it comes to, so the very high risk would also be, some aspects of it would be completely prohibited. The pre-market wording that I'm using is the kind of obligations that companies will have before they even put AI on the market, basically before the way they're even in their design, the kind of obligations that they have to take into account. So, and once you have developed an AI that's in conformity with the rules that the regulation is seeking, then the post-market logic will be the compliance and making sure that that application of that AI is also in conformity with the further different legal obligations that the law would impose potentially in the future. I hope that kind of
thank you so much. This is very, very helpful and helps us to put this into perspective. Przemek, you have heard Vigjilenca talk about what she called a mismatch or a gap in ambition between what the AI Act might meant to be and what it actually is in certain perspectives. In your view, where's Europe and specifically the EU headed? Is that description accurate? Is there something you'd like to add or stress or put a different emphasis on?
Thanks a lot, Nick. Well, first, thanks for the invitation. Thanks to you. Thanks to everybody who put work to organize this panel. If I could, I'd also like to open by first and foremost expressing solidarity with our friends and colleagues in Ukraine. It's one of those days where, you know, what we're talking about is extremely important, and yet it's sometimes difficult to focus on that when bombs are flying so close to home. So we're with you, and let's hope this nightmare comes to an end soon. A second thing I'd like to say is that what will be talking about today, especially in the relationship to the AI Act, is a result of work that was funded by Norwegian grants, and I'd like to very much thank Norway for supporting my work. Getting into the substance, yes, I think Vigjilenca put it perfectly, very succinctly, and I agree. Maybe what I would add is, when we're talking about geopolitics of European AI, that's, you know, a broad way to frame the problem. In my view, there are sort of two strands of European policy right now. First of all, in the path for digital Europe, there's a huge investment component, right? So on one hand, European Commission has devoted a lot of money to developing both software and hardware. The plan not yet passed is to spend 1 billion euro per year on AI itself. However, we need to remember that there are other things like the CHIPS Act, like support for cloud computing, where a lot of funds will be directed towards the development of those systems, which is somehow similar to how internet and technology started, and yet it's a bit of a departure of how it's been done lately. The second thing is indeed the AI Act, which is the ambition to, regulate and govern development, and especially putting on the market of AI systems. I'm extremely skeptical of that act. I don't think it will do anything good, and it will actually create a lot of problems. And the reason for that is just like all those other elements of the European legislative package right now, the ambition of the AI Act is to govern horizontally all AI systems that are there. Europeans, very much unlike the Americans, have this obsession with uniformity. There's one regulation for everything. There's an omnibus regulation, so there's no holes. Allegedly, it's supposed to be cheaper to market products because the rules are uniform. And yet the problem is that, as Vigjilenca said, the AI Act divides AI systems by the type of risk. And it essentially just puts rules for the high risk AI. There are some prohibitions on prohibited AI, some things on the lower risk, but the category of high risk AI is what the regulation governs. And what it's supposed to do is that whenever you create such a system, which is either a product safety part, which is maybe where it will work, or when it's used in one of those areas that are treated as high risk, education, vocational training, employment, but also border control, judicial applications, etc. The company putting the product on the market is supposed to develop a risk assessment plan. However, the regulation never really says what those particular risks are. So just like with the GDPR, where you're supposed to just process data for the purposes for which it was governed, but the GDPR says nothing about which purposes are allowed. Here you're supposed to create an assessment of the risks that AI will create, but what is a risk here, what is a bug, and what is a feature is left to those companies to decide for themselves. So I think it will just create a lot of documentation that no one will read without really challenging the way that AI systems are developed. And yeah, we can get deeper into the details of why this is so later, but that would be my overall assessment. Thanks.
And I look forward to that. Thank you so much for this intervention. And let me pass it over to Kirsten. Kirsten, are you equally pessimistic about the impact of, or potential impact of, this piece of regulation? And more generally speaking, which direction do you perceive the EU to be headed when it comes to AI policy?
Yeah, thank you. Well, first of all, thanks also from my side for the invitation, especially on a day like this. It's really good to think about something else. As you mentioned, I work in the Federal Chancellery here in Germany. As you can imagine, it's been a very intense 48 hours, and all my thoughts were with the Ukrainian people during these last few hours, and also from my side and from our side, very worried about the situation, and all my sympathy goes out to the people of Ukraine. Having said that, I had to smile maybe for the first time in those last few days now, because I think what we can really see with Przemyslaw and Vigjilenca is those two things that I see coming together in the AI Act as a policymaker. And that's the sort of very oscillating views in a very, very European discussion on AI. And those views are, I see two kinds of people as a policymaker. One type of person that sees AI as sort of the silver bullet, huge opportunities, amazing chances, a solution for almost anything. And then there's the other type of person that sees AI, even AI made in Europe, whatever that might mean, as dangerous, bias in data sets, discriminating, and it needs to be regulated. And I think what the Commission has tried to do in its proposal is to sort of blend those types of really broad points and sort of conflicting interests that come together in Europe. Actually, not just when we discuss AI, but when we discuss technology as a whole in Europe. It's always those types of discussions. And as a policymaker, I see them a lot. And what I think will be the major challenges is lots of legal questions, of course, attached to the AI Act, but much more broadly from the Chancellery, you can see how polarizing bringing forward a proposal like that has been within Germany, within the community, but within Europe. We made a graphic for the Chancellor to show him where everyone stands. And it's really like two fronts. One set of member sets over here, says the AI Act is going to sort of regulate AI on a global level, and that's a good thing. And then there's the other set of policymakers that it's sort of down here in member states that say, okay, this is just a huge bureaucratic burden. It will kill the very slight efforts of developing AI that we have in Europe. And also, please think about that we as policymakers do not even have the people in our governments that could enforce these rules. And so we have very practical problems. And those two very oscillating utopia, dystopia, not practical and bureaucratic, and saving sort of the values that we share in Europe on a global level, you can really see coming together in this AI Act. And I think some of the major challenges are on a cultural and sort of policy level. Then, of course, the legal complications have already been mentioned. And then there's a lot of things that are forgotten in this AI Act that nobody ever discusses. And that's the sort of attempt of the European Commission to bring small and medium enterprises more into the AI business and give them sandboxes and give them funding and sort of, enable them somehow to at least, have some chance in the global market against the big American corporations and even Chinese competitors there. I'm not sure that that's discussed a lot, and I'm not sure it's worth discussing because it's such a slight effort from our point of view. But connected to that, we shouldn't forget that the AI Act is just one tool in the toolbox of this, as Przemyslaw has mentioned, the whole digital strategy. We've seen this week the Data Act proposal for the first time, which I think from my point of view is much more fundamental than the AI Act, because data is hardly used in Europe. We have a very strange relationship with data and with the use that we make of data, but without data, there's no AI. So regulating AI that doesn't really develop in Europe is futile if you don't have a database that you can build it on. So I think in this Data Act, a lot of challenges come together. It's very interesting for a policymaker to be part of it. And I can see all the legal challenges, but I can also see all the policy challenges and the cultural challenges, not even mentioning bringing our citizens along, that this act will pose to us in the next few years until it actually becomes law and even beyond, of course.
Thank you so much for that, Kirsten. And I think this is really a core question, this tension or balancing, if you want, of industrial policy, of enabling innovation on the one hand, and of regulating or trying to rein in certain threats that might stem from that technology. Now, let me play that back to Przemyslaw. Przemyslaw, Kirsten pointed out that EU policymakers saw that tension and have taken it into consideration and have tried to, well, bridge that gap to some extent. To what extent do you have the feeling that they have been successful when trying to balance these two things? And the one other additional thing that I just wanted to wanted you to maybe take into account is that, of course, industrial policy can take different dimensions, right? It can take the dimension of specifically creating a framework that enables and allows for innovation. That's one approach to industrial policy and to supporting the development of a certain technology. Another approach to supporting the development of technology, more generally speaking, maybe, is to say, well, the states should step back and should just let innovation occur, so to say. And if you look at, or if you take into account both of these dimensions of industrial policy and try to balance them, or try to balance them with whatever precautionary measures we would like to see in action, did the EU Commission, did the EU regulators, were they successful in that balancing act, or did they go off the rails into one direction?
Thanks, Nick. Just for everyone who's attending, we need to remember that those are still proposals, right? So what the final law ends up being, we'll see in a couple of years. So, we can't really assess how successful they were. We can talk about what we think about those proposals. On the question of industrial policy, I'll come back to that soon. But on the question of regulation and innovation, I think this is very important. I don't want anyone listening here to think that I'm saying, or anyone is saying, that innovation is threatened by regulation, that we should not regulate AI or anything because this is bad for innovation. This is not true. Properly done regulation can actually be very good for innovation, right? Because the risks are lower, we know what to expect in the future, and the rules by which we are to play are also clear. Bad regulation is bad for innovation, and I think the AI Act is a piece of really bad regulation. Why is this so? This looks like a very heavy, profound regulatory tool, right? It's long, it creates a lot of obligations, it will cost a lot to implement it, but it shies away from actually making the political choices, right? It delegates them to the market. When it comes to questions like, what is a risk that an AI system used for border control poses, right? Let's imagine that somebody is marketing an AI system in Europe that is supposed to speed up asylum processes at the border, right? And let's imagine that it seems that this system will speed up the process 5 times, but it will give us 10% false positives and false negatives, right? So somebody might say that, well, this is great because it speeds up the process. Somebody might say, well, it's horrible because it lets in someone who should not get in. Someone else might say, well, it's horrible because it does not allow someone who deserves asylum protection to get in. What is the risk here, right? And the AI Act does not say anything about this. That choice and a choice about every other regulatory problem in AI is left to the market. Either the law firm that will develop the risk assessment plan, or a standard setting body in those areas in which there actually will be standards adopted. So it feels like we're regulating, it feels like we're solving a problem, right? But we're not doing it. We're just signaling that we care, right? And it's exactly the same as it happens with the GDPR. The problem with, having been working in Europe and in the US, you know that the approach to law is different, right? Americans care about the effects of regulation. Europeans really care about the ideal world that the regulation imagines, right? That's why there is no contradiction between Europeans saying that GDPR is a wonderful law, right? Because it paints this world in which our data is not collected more than necessary and everybody lives by those principles. And if it doesn't work, that must be enforcement. Right? The only thing we talk about when it comes to GDPR critically in Europe right now is enforcement. It doesn't work. We should probably speed it up. Well, maybe it's a bad law, right? Which is what the Americans are saying. It never could have worked in the first place when you impose this type of requirements on private businesses without pairing it with regulation of purposes of process. And I just fear that this will be exactly the same with this act, right? Europeans will feel good about themselves. They will say, well, we regulated it. And if there are problems, that's probably because of enforcement, whereas actually it's the problem with the substance of the law.
Nick, may I jump in here? Because
I was going to give it over to you from the feel good industrial policy. That I thought was a perfect segue to give it over to you. So do you agree? And do you also see this as mainly signaling regulation or feel good industrial policy, or would you frame it differently?
No, it's very, very interesting to me that Przemyslaw used the word signaling, and I don't know if that's our former ISP residency kind of background in common that shapes a bit of our vocabulary, because actually even in my opening statement, I was going to sort of suggest that sometimes we legislate not so much because we genuinely want to make a difference or that we expect that things will be very different. It's more a signaling. Laws are always a signal that we care. And that signaling can happen because there's public pressure to do something about something, right? So that, you know, Europe takes facial recognition seriously, that Europe takes biases in AI seriously. So it's more like, yeah, we are doing something about that. And I think, but so sort of, I agree and disagree though with the signaling metaphor, but also in terms of the ambition and the implementation. I don't think the sort of the divide between the sort of the US and European approach to use Przemyslaw's sort of division is necessarily so much there, in the sense that I think both sides want to have an effective law. I think the means towards achieving an effective law, what constitutes an effective law potentially is very different. Now, what I would like to actually share more also from a personal perspective, you know, both as someone who obviously works with European law, but also as someone who's had a lot more practice in, especially giving startups in New York advice when it came to the GDPR, for example, before the GDPR came into force, that really kind of put me in Przemyslaw's sort of front in terms of questioning my own sense and what we think about the law. Because the first question a company generally asks itself is, how does enforcement look like? Right? How much does it cost me? And how much, and what are the chances of me really getting caught? What does it mean what does it mean to have the appearance of compliance? And that's actually the problems, and not to change the topic in AI, but I think GDPR analogy can be helpful because there we already have a concrete law that's already in place and we have some practice. In my view, the problems with the GDPR and similarly now to AI is it's not merely a question of enforcement, that's already practical. It's the fact that they do not fundamentally challenge the business models under which the tech industry actually operates. And actually the risk that we run by creating laws like GDPR or potentially having the AI Act in the future is that we sort of almost legitimize what has already been taking place, because our starting point is the kind of business model that already exists, and the kind of incentives that the laws try to have in the GDPR example, right, in the instance of trying to push so much for consent. It's trying to rebalance a power-dispowered dynamic, but without fundamentally actually questioning what does the business model actually do, and can that be changed to begin with? Now, the AI Act tries to do that a little bit differently, a little bit more by sort of, as I said, in sort of these pre-market, of course, because it's also very different in the sense that it, even in the way that AI can be designed, can already be harmful. But I think the question fundamentally is that with the AI Act, the point is to signal that there is something that we should be doing. And I think that connects to maybe what, what we see a lot of discussion around the Brussels effect of European legislation, and to what extent, is this sort of European Union trying to flex its muscles and show that it's this global leading legislator. As I said also in my opening points, it's a bit easier for the EU to do that because there is the main industry is also not there, or because, of course, there's more flexibility in terms around of what kind of enforcement can take place. So sort of to make this a little bit more concrete, the fact that there is signaling, should we be critical about that? Should we say, to sort of, I can understand Przemyslaw's frustration in a way and saying, no, this is not good enough because you're not actually doing the work. You're just trying to create a theater of appearance of some sort of accountability or lawmaking, but you're essentially not doing it. And I agree, as I said, to the extent that when we have a law and we set things into paper, we legitimize a little bit of the practices that we already have, and then it's much harder to go back and change the direction that we've had. However, signaling as law is not a bad thing, and I think to the point about missing definitions or leaving more discretions, I am not per se against it, because there has to be some level of flexibility around it. I think when we try to say, what would be an ideal balance, to your point, Nick, as well, in terms of also trying to satisfy different interests. As Kirsten was trying to say, this is not an easy playing field where the positions are just so dispersed and very different and very hardcore in a way in terms of where people sit around these things, or where they would like to appear to be sitting, especially as policymakers vis-a-vis the citizens. I mean, to give examples, as we saw in the Netherlands, whether Dutch enforcement does have right to profile individuals or migrants or requests, or to what extent the French authorities, after they have information of possible terrorist attacks, to what extent that can be used. These are very sensitive questions, because we're talking about AI a little bit without missing the context in which it's also the political and not just the legal context in which these kind of considerations have to take place. And I think they're trying to sort of signal, to use the word again, around what can be okay or not okay, to what extent there should be a judgment involved around also maybe a post facto kind of assessment. I think that is in itself can be a good thing. I don't think we should necessarily completely sort of say, well, let's give up on this, or let's not have this because it's too vague or it's not ambitious enough. And I think obviously, and as I say, and I say this as a European lawyer, when I also teach my students about European law, I think a typical approach, and very rarely will you find a directive or regulation that makes everybody happy. I think the Commission generally is satisfied with itself when it has made equally everyone unhappy. And so the equally unhappy to both the industry and everyone else, I think, is sort of the middle ground approach of sometimes that we mostly see with these sort of acts.
So the AI Act made everybody equally unhappy. Kirsten, let us build on that. So there seem to be two tensions that both Przemek and Vigjilenca pointed out. So one tension is sort of on substance, meaning, do I want to outlaw, prohibit certain practices, or do I not want to outlaw that? That's what I take Przemek's example to mean. There might be a benefit, there might be a cost to doing that, there might be challenges created by employing AI. And now the question is, should we allow for that? Should we support that? Or should we completely prohibit it? That's sort of one tension. And the other tension seems to be, at least to me, who should make the decision on whether to allow that or not? And I, again, try to build on what Przemek and Vigjilenca had mentioned. So one way of solving that tension is for the EU legislator or national governments, or in a joint endeavor, to just make that decision, right? Say we could and should allow these practices for purposes X, Y, Z, and not for A, B, C. Again, I'm mainly paraphrasing what Przemek and Vigjilenca have said, or we take, or the EU takes an approach in which that decision is delegated to someone else, whether that is the market in general, whether that is law firms, whether that is auditors, or whether that is some other institution, but the lawmakers themselves don't make that decision. Where do you stand? First, on the sort of prohibitive, non-prohibitive scale. Second, on the scale of this is a decision that lawmakers should take, versus this is a decision where we only want to set up a process, and that process then will lead to certain results that we might not know yet.
I think my answer lies a little bit in the headline over this panel. I think if we only view the AI Act as a law or potential law in a few years, we would overlook the fact that it's actually a geopolitical move. And as much as we might criticize a lot of details from GDPR, it was a strategically geopolitical move that has put the EU back on the technology map, if you want to say so, especially in the absence of other avenues. What I see in those two tensions that you mentioned is the AI Act also as a geopolitical instrument, like one more tool in a toolbox, especially in the absence of other tools. If we look at other processes, Trade and Technology Council with the US going nowhere, Privacy Shield negotiations not really going anywhere either. No other avenues to discuss these kinds of issues like G7, G20, barely any movement, if at all. So on those two points, the EU really here is trying to make a very strategic political move rather than a legal move from my point of view. And I think when it comes to the question that Przemyslaw raised, you know, who is sort of, is it a flaw to put the decision on the market or on law firms? I'm not sure that it's a flaw. I think it's kind of, from the point of the European Commission, it's a design principle, because there is certainly, from a German point of view, a sort of overemphasis on anti-American, or not anti-American, that's probably very strong, but very critical of American companies, sort of current in the EU Commission, that comes out in this putting it on the market, and then you know, having big fines, etc. Because what they think about when they make those choices is actually the companies that we all know, the GAFAM companies, etc., and that they want to push it onto. And I don't think that's a flaw. I think that's a design principle in that legal act. I think what they don't see, or see too little, is that they harm a lot of European companies in the process. But that's sort of, that's a decision that they make within the Commission, and that they consistently make also in the other digital laws that they've made, the Data Act as well. That's a design principle. So personally, and also from the point of a German government, we see that very critical. We would like to have it otherwise. I'm more on the sort of on the side of Przemyslaw there, but when it comes to the European sort of strategy on those ideas, that's certainly a design principle. Yeah, so I think the answer always lies there in the idea that this is a geopolitical strategic move that plays out long term. Mm-hmm. And with all its flaws, that's worked for GDPR. And that's certainly the aim of the Commission, certainly the aim of this Commission with President von der Leyen. And they will sort of implement that in any kind of digital regulation that they have. And the member states, especially Germany, are trying to, in the current negotiations that we're part of, certainly to sort of push it in a little bit of a different way. But from a strategic point of view, that's a very clear decision on the part of the Commission, I think.
Thank you so much. And just for clarification, a quick follow-up. You said you fully agree with Przemyslaw on which of the dimensions? On the dimension that we should have regulated more directly, or on the dimension that that certain usages should have been reined in more forcefully?
I think on the point that certain usages should have been reined in
okay.
more directly, because that's actually, I think, at least from our point of view, that is the prerogative of government.
Okay.
When it comes to these laws, I mean, that's what government is for. And also, you have to see that one aspect of this act is also to signal, when it comes to signaling, to signal to citizens. Mm-hmm. Who not a small number of Europeans are afraid of AI. They use it in their phones every day, but they're still afraid of it. So I think the point of government is also to regulate more directly there. So that's definitely something that we try to make clear in the negotiations with the Commission.
Thank you so much. Now let's try to switch gears a bit. With that, let me start with Vigjilenca here. So in the context of the GDPR, there has been much talk about the extraterritorial effect of the GDPR. For those who haven't been closely following that, that basically means that the EU applies a law beyond its borders, and well, beyond the borders that others deem appropriate for the EU to capture by its regulation, one might need to say. And then there's a long discussion to be had on what the appropriate boundaries of that are, obviously. How do you see that play out for the AI Act? And maybe you can contrast it a bit with a separate phenomena, not extrajudicial reach, but what's sometimes called the Brussels effect, meaning the impacting of regulation at a global level by defining certain rules in Brussels.
Yeah, thanks, Nick. And actually, that's a very important point actually to reflect on these things on in light of the fact that we're saying there are different approaches between the US and the EU, as we already discussed, or the fact that even within Europe there can be tensions or different interests among member states. So it does indeed raise the question, to what extent, and I think that's an inherent, it's a very sort of in a way traditional, just to be clear for the audience maybe that are not with legal background, these sort of questions around extrajudicial, so you have your jurisdiction and sort of going further than what your jurisdiction allows, kind of legislating beyond those jurisdictional borders, is not specific to this, to European Union or to these kind of regulations. It can be inherent. The one thing, the first argument to say in that front is part of it's inherent a bit in the field. GDPR would honestly make very little sense if it wouldn't have that ambition to sort of apply also beyond strictly, because we're talking about a field that does not confine to the physical borders, right, that we traditionally have for applications of law. And so in that sense, it's a bit inherent. I would say my first response would be, it's a bit inherent in the field itself, that to try to do a more adequate reach of or the effectiveness potentially of the rules you're trying to take in place, that you would need to make sure to find a way that it's not strictly for companies that are based in Europe, because that is definitely the case that we will be seeing with the AI. The fact that the moment, and we see that with the GDPR, so the commonality there is that as long as for in the GDPR, European citizen data is concerned, even though you're, as I said, a startup based in New York, you still have to take GDPR into account. Or in the case with the AI, the fact that you are going to be targeting or using the AI that addresses EU citizens, that also reaches. I think there I can understand the concerns, and I can definitely understand sort of the skepticism around saying, well, what gives one legislator the legitimacy to overreach sort of beyond its kind of physical, traditional legal borders. But again, in ensuring the effectiveness, which I am generally more in favor of, I can see the rationale of why that's necessary to be done. Now, moving on to the point about the Brussels effect, which is not so much only that these things are imposed, but that actually that there's the influence at stake, in the sense that they are inspired or people take. So one thing there to say, and I'm going to use also the example when it came down to GDPR and Europe and Japan. What we saw there is a bit of a combination of both of these approaches. So on the one hand, the EU was very clear to Japan saying, well, you know what, we're not really going to sign a trade agreement with you unless we really make sure that the privacy levels that you can ensure are the ones matching the GDPR. And so there, that was not so much sort of just trying to be an influence. That was really a much more, not just a carrot, but actually a real stick in terms of saying, well, we're only going to move forward in doing this if we are. So what we see the privacy aspect there becoming in the context of European Union is what human rights became 20 years ago, that it suddenly became impossible to, for example, in the context of trade, to trade without having provisions that were not previously at the time were not seen strictly to be trade related. So in that sense, the EU has that tool its force because of its market power to try to leverage. So it wouldn't be just a question of that these other legislators are so fascinated by the rules. It's more a question of, well, if we want to do business in Europe or with Europe, we're going to be actually having to come closer a little bit to these standards. But there is also a level to some degree of pure inspiration, if I can say so. And that comes from maybe especially in legislations that are, European Union is a sophisticated legislator. If you look at and what I mean by that, I mean the kind of resources also that it has, the kind of discussions, the kind of expertise, the kind of responses that have been going through. So in a way, actually, it's doing the heavy lifting or doing the heavy work sometimes that not many countries around the world would be able to do or have the expertise or the availability of resources purely in terms of the responses that we saw the Commission taking into account. Now, the danger there, and of course, I hear the arguments of sort of the new imperialism dimension that is sort of, is this the EU kind of the new colony by, ruling by new rules, it's sort of imposing itself. And there's definitely some concerns there that I share with the scholars that have expressed them. But I think to a large degree, in this sense, to what extent is Europe imposing its own values to the rest of the world? That is also to be taken into account. So I guess, as you can see, I'm a bit more nuanced, and I sort of see the arguments, both the necessity for the rules itself to have a broader reach and why that's necessary, especially for their effectiveness. I do also therefore share kind of the concern that it might be Europe extending its force, legislative force, so to speak, especially in situations, as I said, with the trade agreements, where it's not purely a decision of the counterparty to actually receive these rules, but they're more sort of being pressured to do so. And if we have that in a situation with a country like Japan, we can imagine that in any other context, it wouldn't necessarily be as easy. But the last point here, I'm sorry, but I'm quite actually passionate about this external dimension of European law. I think sometimes when we are, in Europe, when we talk about European law, we kind of lose sight of the fact, and we sort of, or we engage with the US, we lose sight of the fact that there's China, that there's Russia, that there are important other approaches and markets. Of course, also you have the sort of Brazil and India. So there are, I think we shouldn't be trying in any way to think that this is so all encompassing, and the only two diverging views that we have here are sort of the transatlantic views. No, there has actually much more plurality of rules. And to that point, I think Kirsten's excellent point in sort of this geopolitical signaling, to combine the words that we've been using this morning. I think in that sense, I think Europe at least tries to be, it's not a military actor. It's not in many other ways a very strong other kind of force. I think law tends to be a strength. So I think it uses also law as that kind of geopolitical signaling in terms of where it sits and how it can do, using its market, of course, to achieve that narrative. So I'll leave it at that for now, and I hope we can take it further.
No, thank you very much. And measuring success by whether regulation is being discussed abroad, I think the GDPR can certainly claim that at least in this direct dimension, it has been a great success. Before we open it up to questions, and so if you in the audience have questions, please use the Q&A function at the bottom to type up your questions, and I will try to pick up some of them. But before we pick up questions, I would like to touch upon one last theme. And when reading the AI Act, it occurred to me that there are certain provisions in there that, without their connection to AI, they wouldn't have found political majorities. Now, Przemyslaw, I'll turn over to you. You might say you might think or say that well, many of those things are actually not resolved, but I mean, to some extent, there are some prohibitions in there, and to some extent, maybe even setting up a process is more than the legislature could have passed in other dimensions, hadn't it been for the connection with AI. So looking at provisions prohibiting discrimination, or trying to rein in bias, or even going as far as trying to prohibit or outlaw some types of deception, seems to go far beyond what without the AI context would have been politically feasible. Do you think of AI as a technology that sort of catalyzes regulatory action, or is that a wrong way to think of technology, and specifically of AI?
That's a great question, Nick. I haven't thought about it. That it's not really that the European lawmakers actually think that AI itself is the problem. Is that this is sort of what gets people excited, like blockchain or all those other things that suddenly mount political move. I don't think so, though. So what exactly the prohibitions in the AI Act will end up being, we'll see, right? We have the comments from we've seen what some people in the parliament and what some people in the council think, but the exact wording is yet to be seen. As of now, those prohibitions on manipulation are full of loopholes, right? Like the need to lead to physical or psychological damage. There's no economic harm. The discrimination is not outlawed itself, right? Like it sort of needs to be part of the group. we could get, I mean, we can't, but if someone's interested, read Article 5 of the proposal, and you'll see that those are like really loopy prohibitions. And so on your point, maybe, I mean, I could see that work, right? Certain things that are just way too difficult to normally mount the political power for can be achieved when we sort of scare people with AI. But like, just let me reiterate one last time that there are hard choices to be made here, right? Sort of, it's not that there is one single metric along which we sort of assess how much risk we are willing to accept in a society, right? There are hard political choices about the shape of the world we want to live in, right? Like, do we want more data collection and sort of personalization online that maybe leads to shaping of some people's preferences and behavior to more than we want, to a higher extent that we would like to, but gives everybody Facebook or Google for free? Or do we want to change that, right? Like there's a wide spectrum of decisions to be taken that the lawmakers shy away from taking. They delegate it to private companies, and they frame it within the narrative of fundamental rights, right? Like everybody feels like this regulation is being passed to protect the fundamental rights of Europeans, and yet it's being delegated to law firms that will do it only in the interest of their clients. So yeah, I mean, that's an interesting point, but I can't imagine this could work this way, but I don't think this is what's happening here. And one last sentence on the extraterritorial effect. I think if we really were promoting a piece of legislation that advances human rights, I would be much less skeptical I would be much less nuanced than Vigjilenca is. I say go for it, right? Like put privacy, put democracy, put rule of law in all the bilateral investment treaties, just go for it. But we're not doing that, right? We're only exporting the narrative of fundamental rights protection, while in the end creating a neoliberal paradise that is, you know, forced into law. So in this sense, I don't think we should be exporting this more.
Thank you. And we are coming to an end with identifying neoliberalism as the core problem. I would like to open it up now to the questions. And we have already gotten some great questions. I think one of them would be a perfect fit for Kirsten. So we have a question on the problem of regulatory pace. How could we address the challenges of regulating the use of technology resources or tools that are evolving at a faster pace than the legislative or regulatory processes that most of the people regulating the issue worldwide are not necessarily experts, in addition to the enforcement challenges?
That is an amazing question. That's sort of the question of my life, actually, because it is certainly true that technology evolves so much faster, and that actually that's one of the things that when I read the AI Act and when I think about that it will come into effect maybe in, like, if we're very fast, in like maybe 1.5 years or 2 years, if we're really, really fast, and the way we negotiate it, it's at such a different level. But that's, I think one of the broader points to make here is that a lot of the, and this goes to your question that you asked, Przemyslaw. It's a really, I think a lot of politicians and people project societal hard choices and questions onto technology that are actually unrelated, really unrelated. For instance, you can see that in the problem of hate speech. A lot of people in Germany ask if we can regulate like Telegram and kick it out of Germany. Can we regulate Facebook? But actually what they really mean is not can we regulate hate on the internet, but can we regulate hate, full stop. Because the problem isn't hate on the internet or hate speech on the internet. The problem is hate. And people just use technology as a tool to express it. And it's faster and it's more sort of assertive on a certain level, and just more sort of filtrating into people's lives much more. And I think the question that was asked from the audience is an excellent question, but it doesn't solve the problem that we also have to have societal and broader political discussions on certain behavior and on what's acceptable or not. And yes, we need to be faster in regulating tech, but that doesn't save us from having these discussions. And those discussions are not to be had in any fast way. You need to have them in full. So I think not to shy away from that question, we're certainly right. And we need a much more diverse government, especially in Germany, where we're all, I'm not a lawyer, but most of us are lawyers in the federal government. We need a much more diverse background in people that do the regulation. But it doesn't save us from asking the questions in society. It's not about tech really there, it's about societal problems in many of those cases.
Can I very quickly, Nick, just say—
Please do, of course.
I absolutely fully agree with Kirsten, and such excellent points sometimes that, we're sort of projecting our issues, but I think we sometimes tend to treat tech and everything tech related as if it's completely something new, never seen, never unheard of. And that's just simply not true. It's inherent of law to deal with fields that change. Think of pharmaceuticals, think of any industry, think of aviation, think of anything else that law regulates, and we sort of agree, or should in principle agree, that there should be regulation or rules around it. I think it's been an argument so much used by tech companies themselves for so long that they're so different, that they're so special, that it has penetrated a bit the public discussions. In order not to have any regulations, or to claim that self-regulation is the best way to go forward. So I simply just also want to very strongly say, I disagree that law somehow fails. Of course, I don't disagree at all. And I think the person asking the question very rightly points out that sometimes maybe we lack the expertise, or of course there can be lobbying around regulations and all the problems that we're aware of. But let's not treat tech as something that is so different from any other field that law does regulate and needs to understand. And that in that sense draws the balance of creating sufficiently specific but also broad rules enough that things can be regulated without that being hampered, or without things having to be so uncertain or left to self-regulation.
Thank you very much. And to take the fully constructivist view, I mean, we make choices inevitably. We make choices when we pass a regulation, we make choices when we don't pass a regulation. And in both instances, we're likely ill-informed or not fully informed. I would like to pick up one last question before we need to close, and that is, in some ways, the GDPR has already partially regulated AI. And the person asking the question is referring to Article 22 of the GDPR here. And local court cases have also imposed a transparency requirement on decision-making and product development. How much of the proposed AI regulation, how much does the proposed AI regulation add to the present AI GDPR regulation on the use of personal data? I don't want to call somebody out, but Przemek or Vigjilenca, maybe could one of you take the doctrinal question?
Yeah, Przemyslaw, please go ahead, and I'm happy to.
Sure. So look, Article 22 is a good example of what we've been talking about, right? It applies to fully automated decision-making processes that are based on personal data. That means that if there's an algorithm that makes a strong suggestion to a person, to a human being that rubber stamps it, there's no prohibition, right? If it's based on data that is not personal data, that is not identifying or not relating to a person that could be identified, it also falls outside of the scope of the GDPR. So when it comes to showing ads online, that probably does not apply either. So I think it regulated AI on paper. It's one of those nice articles that we like to boast that we have, but I don't think it had that much impact. And in this sense, the AI Act would go much further, right? There is no requirement. It's not about automated decision-making in any way, right? It's about marketing of AI systems that are understood as pieces of software developed using those techniques like machine learning. So yeah, I mean, it goes much further, but it goes in the wrong direction.
Well, thank you so much. This is a wonderful point to bring this panel to an end. I would like to say special thanks to Max and Jonathan, and I would like to give it back to Kyoko. But before I do that, Of course, also thank you so much to the audience and special thanks to our wonderful panelists. Kyoko, over to you.
Thank you for the excellent panel. As we have seen with the EU's GDPR, EU's regulation and policy on AI will also have a significant impact on the world. And we should continue watching where the EU will go in this area. We learned a lot from today's panelists. The video of today's panel will be uploaded at the Yale ISP's AI governance website, along with the past panels. On behalf of the Georgetown Institute for Technology, Law and Policy, and our co-hosts at the Yale Information Society Project, I would like to thank all the panelists for sharing their expertise, their insights, and their time. Our next panel is AI policy in Japan on April 8th. I look forward to seeing you then. Thank you for joining us from around the globe. Have a great day or evening.